Well, hello. We're thrilled to welcome you here today to the Anti-Defamation League's 25th Annual Supreme Court Review, presented both in person this year and online. I'm Rachel Robbins, chair of ADL's National Civil Rights Committee. This program is presented jointly with the National Constitution Center, and we are so grateful to our partners here, Jeffrey Rosen, Lana Ulrich, Tanaya Talber, and their wonderful colleagues. Before we hear from our distinguished panelists, I want to recognize my predecessor as ADL's National Civil Rights Chair, John Harris, and ADL's Senior Counsel and Director of Legacy, Steve Friedman, who are here today. I also want to thank other members of ADL's team who played a key role in today's event, including Karen Levitt, Aisha Irvis, Samantha College, Jessica Shapiro, Rachel Newman, and Abby Crane and her colleagues in the Philadelphia office, as well as many other ADL staff across the country who made this event possible. ADL was founded in 1913 with the mission to stop the defamation of the Jewish people and to secure justice and fair treatment for all. Today, ADL continues to fight anti-Semitism and all forms of extremism. Materials for today's programs are available on the ADL event website, along with bios of our brilliant presenters. And let me introduce them very briefly, and it is very brief because their bios are quite impressive and quite long. I will start with Erwin Chemerinsky, the current Dean of Berkeley Law. He frequently argues appellate cases, including at the U.S. Supreme Court. He's the author of 15 books and more than 200 law review articles. And Erwin was the speaker at the first conference 25 years ago, but he was in middle school. Next, we'll go to Dr. Marianne Frank, is a professor of intellectual property, technology, and civil rights at George Washington Law School. Dr. Franks is the author of the award-winning book, The Cult of the Constitution. Her second book, Fearless Speech, will be published in October of this year. Next to Marianne is Miguel Estrada, who's a partner in the Washington, D.C. office of Gibson, Dunn & Crutcher. He has argued 24 cases before the Supreme Court. And next to Miguel, Gregory Garr is a partner in the Washington, D.C. office of Latham & Watkins and chair of the firm's Supreme Court and appellate practice. He previously served as the 44th Solicitor General of the United States, and he has argued 49 cases before the Supreme Court. And last but not least is Fred Lawrence, who's the 10th Secretary and CEO of the Phi Beta Kappa Society. Fred is also a distinguished lecturer at the Georgetown Law Center. He is the author of Punishing Hate, Bias Crimes Under American Law, and he has been involved in this conference for 24 years, also from middle school. And finally, our moderator, Amy Howe, runs the website Howe on the Court and writes for SCOTUS blog, for which she previously served as editor and reporter. So there is so much to discuss from this amazing panel, and so Amy, the floor is yours.
Thanks so much. I don't usually feel comfortable talking about something without checking it with my fellow panelists in advance, but I think I can say on behalf of everyone that we are delighted to be back here in person. And this was truly a historic term that we're going to be talking about today, so much so that we can't even begin to cover all of the major cases from this term. So we're going to be focusing in particular on the ones that are of interest to this audience. And we're not going to be able to spend as much time on the major cases as we'd like. We could easily spend the entire 90 minutes talking about just the presidential immunity cases or just the administrative law cases. But we're going to do our best, and we'll take your questions towards the end. And we are going to kick it off with one of my favorite July traditions, which is hearing an overview of the term and trends from Erwin Chemerinsky.
Thank you. It's an honor to be part of the program again, and wonderful to be in person. As Amy said, it was another monumental term in the United States Supreme Court. The court decided 59 cases with signed opinions after a brief and oral argument. That seems to be the new normal in terms of the number of cases per year. The last 2 years, it was 58 cases. But I've said of this program previously, in the 1980s, the court was deciding over 160 cases a year. In William Rehnquist's last term as chief, October term 2004, the court decided 85 cases, and it's gone down by over a quarter since. If I had a theme for this term, I would say it's a very divided Supreme Court. Of the 59 cases, 23 were 6-3 decisions, another 5 were 5-4 decisions. With regard to the 6-3 split, the most common division among the justices was ideological. The 6 conservative justices, Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, the majority, and then having Sotomayor, Kagan, and Jackson a dissent. But there were certainly other 6-3 combinations this term. There were some cases where the dissent was Justices Thomas, Alito, and Gorsuch, who have emerged as the most conservative wing on a conservative court. One of the things that was stunning this term was that even in cases that were unanimous or near unanimous, there were a large number of opinions and often heated disagreement. As an example, I think one of the more important decisions of the term was United States versus Rahimi. It involved a federal law that makes it a federal crime for a person under restraining order in a domestic violence case from having a firearm. The Supreme Court, in an 8-1 decision, upheld the law. But there were 7 different opinions written. Chief Justice Roberts wrote the majority opinion, and he took an originalist approach, continuing to say, we determine what laws violate the Second Amendment now by looking at history, especially that in 1791. Justice Sotomayor and Jackson wrote separate opinions, disagreeing with that approach. They wanted to focus on the contemporary need for this law in saving lives, especially women's lives. But then Justices Gorsuch, Kavanaugh, and Barrett wrote separate opinions, disagreeing about how to apply originalism in a case like this. Only Justice Thomas dissented, again from a very originalist perspective. Or another example of this, a case that we'll talk about, Moyle versus United States, that involved abortion and the Emergency Medical Treatment and Labor Act. The Supreme Court dismissed the case without a decision. The court said certiorari was improvidently granted. But still, there were 4 opinions written, including a very angry dissent by Justice Alito, joined by Justices Thomas and Gorsuch. In terms of the individual justices, in prior years we've talked about, is it really the Roberts Court? And the answer for this year is emphatically yes. Chief Justice Roberts was in the majority more than any other justice, 96% of the time. He also wrote so many of the most important cases, Rahimi, Trump versus United States, the administrative law cases. By contrast, Justice Samuel Alito wrote only 4 majority opinions this term, the fewest of any justice, and the fewest of any justice in recent history. One wonders if there were cases where he was assigned the majority and then lost it along the way. Many have observed that we heard Justice Amy Coney Barrett's voice more this term. There were a couple of cases where she joined with the liberal justice in dissent. To be sure, overall, she most frequently voted with the conservatives. But sometimes she wrote a separate opinion, urging a more moderate approach. In this term, at least, Justices Sotomayor and Jackson are the most vocal liberal justices on the court. The tone of so many of the opinions this term was angry. There were angry dissents from both conservative and liberal justices. Over a half century ago, someone talking about the Supreme Court with Justices Black, Douglas, Jackson, and Frankfurter, many of whom didn't like each other, referred to them as, quote, scorpions in a bottle. If I was to describe the current court, I would say they're angry scorpions in a bottle.
Thanks, Erwin. One of the themes at the court this year was the First Amendment, and then sort of some combination of the internet, content moderation, coercion, and liability. And so we're going to start with two of those cases, Moody versus NetChoice and NetChoice versus Paxton. Marianne, can you tell us about those?
Sure. So both of the NetChoice cases came from state laws originally. So Florida and Texas both had passed legislation that purported to tell social media platforms and other tech companies essentially what they could do with their services and their platforms. The laws are a little bit different from each other, but both of the laws said things like you can't take down content based on viewpoint, essentially. So the kinds of things that we are accustomed to thinking of Facebook and Twitter, now X, as doing in terms of maybe removing content or downranking it or maybe sorting it in a certain way. These laws tried to say you can't do that based on viewpoint, with a few exceptions. And when you do remove content or make it less available, you have to provide detailed explanations to the users that are the subject of those actions. And so in both of these cases, there was an organization called NetChoice, which represents a lot of these major tech companies. And NetChoice sued in Florida and in Texas both to say this law violates the First Amendment. And they brought what's called a facial challenge, saying it is just on its face, it's unconstitutional. And then you had a really interesting development in that the 11th Circuit, dealing with the Florida law, says NetChoice is right. We're going to enjoin the law. It doesn't go into effect. Whereas in Texas, the 5th Circuit said, actually, we think NetChoice is wrong. Texas is right. None of this really implicates the First Amendment. These social media platforms are not really like normal private actors. They're more like common carriers or something similar. And therefore, it's okay, and in fact, good for the state to step in and regulate them and tell them what they can and can't keep up. So you've got these two very different decisions, and then you've got this coming to the Supreme Court to make some kind of sense of this. And the Supreme Court basically says, well, we're not going to decide this on the merits because of the facial challenge problem. In other words, because NetChoice said this is just unconstitutional on its face, the court says the proper way to evaluate that is to think of all the ways in which it has a legitimate sweep, all the ways in which it has impermissible reach, and see whether or not there is a bad balance there, and then strike the law down. And the court says we don't have enough information about this because this is complicated. Facebook is one thing, their feed is one thing, Etsy is something totally different, review systems are different, algorithms that work for search are different than content moderation decisions. They said all of this is too complicated, and so we can't really decide based on that. So we're basically sending this back. We're vacating what those circuits did, 11th Circuit on the one hand, 5th Circuit on the other. What that means is the state of play is that the laws are enjoined. They are not currently in practice. They're not in play. But Justice Kagan, for the majority, didn't just say that. She said, we really need to note, on top of this, even though we're not dealing with the First Amendment merits, we do need to send a signal, especially to the 5th Circuit, because they got everything wrong. And this was one of the many times during this term that the 5th Circuit comes in for some serious criticism by the Supreme Court, that Kagan went out of her way to say, look, there are some basic First Amendment principles here, and you applied all of them wrong. You need to understand that when you are a state trying to say, we want to interfere with a private entity's, and by private here just meaning non-governmental, not that it's private in another sense, but non-governmental actors, that includes tech companies, social media platforms, they are not government actors, and so you can't use the language of the First Amendment in terms of restraint when it comes to these private businesses. It's absolutely, of course, the case to say that in many situations, the government is not allowed to get rid of things, downrank them, ignore them, push them out based on a viewpoint. But when it comes to non-government actors, that's what we do all the time. That's what a newspaper does when it doesn't run a letter to the editor. That's what a poetry anthology does when it doesn't publish everything that gets submitted. And it's what these companies do when, as Kagan says very pointedly, when they want to remove neo-Nazi content or when they want to remove content that endorses misogyny. And so what the court basically said is, we're not deciding this on the First Amendment merits, but this circuit, you got this really wrong. We really need to validate the fact that private actors have First Amendment rights as opposed to First Amendment obligations.
Miguel, you have any thoughts?
And, well, yes. I mean, the interesting thing about this is that Kagan says, well, you did not properly apply a facial challenge because these laws, you treated them as if they only applied to Facebook and YouTube, and in fact, for all we know, they apply to Uber and Grubhub, and you got the whole thing wrong. Now I'm going to write an opinion as if they apply to Facebook and YouTube, and actually do the analysis as if I were really just looking at the Fifth Circuit opinion. So she did what the Fifth Circuit did, except that she went the other way. That's one thing. The other thing is that there's a lot in the guts here that the court sort of was kicking down, the road, and you can see it in the concurrences by Justices Barrett and Alito and Thomas. And it has to do with is the platform engaging in an editorial choice when it does this? And what Kagan said in saying that the Fifth Circuit was wrong as to these particular applications is, yes, they are. Barrett says, we'll see about these things later. It may be that the algorithm is completely automated and it reflects no editorial choice. We'll have to see in later applications. It may be that the platform is owned by a foreign company. Foreign companies have no First Amendment rights. All of those things have to be litigated later. And so we'll have to stay tuned. There are all sorts of issues that will have to be litigated in this case as much later.
Thank you. So Greg, can you tell us about the internet and platforms in a different context in Lintka versus Freed?
Sure. So this may be the least notable social media case the court decided this term, but in this case the court actually decided it. It laid down a rule, although it didn't actually apply it in these circumstances. So the basic question in this case was whether or when a public official's use of a social media account triggered First Amendment protections on the part of those who were silenced or blocked by that public official. In this case, individual by the name of James Freed did what millions of people do across America. He opened a Facebook account and he commented on both various personal relationships and the like, as well as his job at various times. During the course of that, he sometimes deleted comments he didn't like and occasionally blocked people that he found particularly offensive. One of the people that he blocked was a man by the name of Kevin Linke, and he brought a First Amendment action against Mr. Freed on the ground that his First Amendment protections had been violated when he was blocked from the Facebook post account that Mr. Freed maintained. For virtually all Americans, that case would have gone nowhere. But what made this case interesting is that because Mr. Freed was a public official, it raised the question of whether or not his maintenance of his social media account, Facebook account, actually triggered these First Amendment protections on Mr. Linke's part. The lower courts in this case both held that the account was primarily impersonal in nature and so did not trigger a state action, and so therefore didn't violate any First Amendment rights on Mr. Linke's account. The Supreme Court in this case basically set forth a two-part test for determining whether or not a public official's use of a social media account constitutes state action and therefore triggers First Amendment protections. One is that the plaintiff has to show that the official had actual authority to engage in social media posting as part of his or her job. And the other is that the official actually was exercising that authority with respect to the speech at issue. In analyzing that and explaining its decision, and this was a decision written by Justice Barrett on behalf of a unanimous court, the court first emphasized that the public officials themselves have First Amendment rights to speak on matters of public concern, but then it pivoted and talked about the ways in which public officials could take on the mantle of the state and posting on their account and basically set forth a fairly high fact-intensive test for courts to use in dealing with a growing wave of litigation with respect to social media use by public officials.
And Fred, you have some brief thoughts?
Sure. So as Greg says, the court lays down a rule in a unanimous opinion. There's a word we're not going to use all that often in this session. And now it gets interesting, which is how is that going to be applied? So Justice Barrett suggests that the city manager in this case and future public officials could simply say on their Facebook page, this is for private use. This is a private use of the page. This is not public. But isn't that what everyone would do if he or she were interested in insulating it from First Amendment being applied? So how are we going to tell? Are we going to try to do some kind of an inquiry into the intent of the public official? Usually in civil rights cases, 1983 cases, that kind of an approach is discouraged. Do you try to do that on papers somehow by what is the most likely use or what would a reasonable person in that situation have been using it for? So the rule is easy to articulate. Now it gets interesting.
Thank you. So now we're going to move on to the third piece of the First Amendment puzzle this term, the social media jawboning case, which I found to be just such a great term, Murphy versus Missouri, and then NRA versus Vullo. So Miguel, can you tell us about those?
This is a pair of cases, one of which has an answer and the other one we thought we had an answer and maybe we don't. So let me start with Vullo, the NRA case. In this case, you have Maria Vullo, who at the time was the superintendent of the Department of Financial Services in the state of New York. She is a supervisor of things like insurance companies and banks in the state of New York. She does not like that insurance companies are doing things like insuring NRA members and doing things like that. And so one of the things that the complaint alleges, and I emphasize that this is a complaint and all the court is doing is reading the complaint, is that she goes, for example, to Lloyd's of London and tells them that she is less likely to investigate their other potential peccadillos if they stop providing insurance to the NRA. There's also press releases and similar actions in which she encourages others not to do business with gun groups or the NRA. In any event, this is what the complaint says, and the issue is whether she has used the power of her office to coerce and others to punish the NRA for exercising its constitutional right to engage in gun advocacy. The Supreme Court, overturning the Second Circuit, rules that there are enough allegations in the complaint for the NRA to have stated a claim that there was a violation of the First Amendment. I will pivot quickly to the twin case here, in which the Fifth Circuit, again, had upheld a claim brought by two states and several individuals against any number of government agencies and basically the Biden administrations, in which claims were made that the government officials had basically strong-armed Facebook and other social media platforms in relation to the basically election interference and mostly COVID-19 to take down multiple posts. The way this turns out is that after the government officials were enjoined from doing all of these things, the Supreme Court unanimously, actually 3-6, found that the plaintiffs have failed to establish standing. There were 3 dissents by Justice Alito, Thomas, and Gorsuch. And what Justice Barrett said in the opinion was basically twofold. You sued only the government agencies, not the platforms, and you sued only for an injunction. And what's wrong is you actually failed to match who was doing what to what happened to you. And you failed to match how what was done was likely to happen to you again. And so, nice try, but this doesn't match up with the doctrine that we require in terms of standing doctrine. If you sue for an injunction, you're required to demonstrate that, this person actually did it to you, not a third party. say Facebook, and that the injunction actually will fix, the problem. If we enjoin the government now, that's not going to keep Facebook from doing this again. And so you have no standing to actually get an injunction against this government actor. End of story.
All right, Marianne, end of story?
Maybe not the end of the story, because in Volo, there's so many interesting things that happen in these two cases and how they're developed. So in Volo, the court, of course, is saying, well, we're just going to accept for now that the complaint is alleging facts that are true. And what's interesting about the Murthy case is that Barrett says, we don't think anything that you're alleging here is probably true. And in fact, this is one of those moments, again, where the court says, hey, Fifth Circuit, stop lying. And so the Volo case doesn't purport to break any new ground. It says you can't, you are allowed as a government actor to try to persuade, to try to convince private actors to do certain things, but you can't coerce them. And there's some disagreement there in Volo, not about that substantive question, but about whether what the NRA had shown up to that point really was enough for the complaint to move forward. I was part of an amicus brief on behalf of First Amendment scholars who said there wasn't enough in the complaint, that these were just allegations that were kind of bordering on a conspiracy theory. What's interesting when you flip to the Murthy case is Barrett says for the majority essentially that this is kind of a conspiracy theory about how you've got government officials allegedly putting pressure on Facebook and Twitter and other platforms to take down certain content or remove certain content. And Barrett says, all of this might be interesting if you had any evidence, but there's so many things here that are just made up, right? And there are other parts of the opinion written by other members of the court to say it's really alarming how error-ridden this factual record really was to the extent that we have one. So one of the most interesting things I think about the Murthy case is a kind of, again, it's a signal to the Fifth Circuit to say, you can't just make things up. You can't just go on your feelings. And if you think about this in the context of the net choice cases, there's a developing message here about how you can't just go around calling everything censorship that you don't like, especially if what you're trying to do as a remedy is to censor other people, whether that's the social media platforms themselves or whether that happens to be government officials.
Can I just say one thing about that? I think a key difference is that in the federal government case, they were seeking and got an injunction, and for an injunction, you usually have to make a factual showing, whereas in the NRA case, they were at the pleading stage. All they were saying is, we intend to prove this if you give us a chance. And for purposes of the stage that the case was at, that can be important.
All right, we are reaching the point of the program where the cases start to get, as my kids would say, a little spicier. So we're going to move on to another big theme at the court this term. Erwin and then Miguel are going to talk about the administrative state and regulatory deference.
I think the most important change in American government since 1787 has been the creation of so many administrative agencies that affect all of us in all aspects of our society. A crucial part of the Roberts Court agenda has been to have much more judicial oversight and control of federal agencies. We saw that the last two terms when the Supreme Court effectively created a new doctrine, the major questions doctrine. The court said, when it's a major question of economic or political significance, an agency can act only with clear direction from Congress. And there's so much litigation going on now over what is a major question? What's enough direction from Congress? This term, there were two major cases I want to talk about that imposed significant limits on administrative power. The first of these is a case called Loper Bright Enterprises versus Raimondo. It involves what's often referred to as the Chevron doctrine. In 1984, the Supreme Court decided Chevron USA versus Natural Resource Defense Council. There, the Supreme Court said, if a federal statute is ambiguous, courts should defer to an agency's reasonable interpretation of it. To give an example, the Clean Air Act says that the Environmental Protection Agency can set up rules with regard to pollutants being put into the air. Imagine the EPA adopts a rule saying only so much of a particular pollutant can be emitted. The Chevron doctrine would say that courts should defer to the EPA there so long as the EPA is being reasonable. The Supreme Court, in a 6-3 decision, expressly overruled Chevron and ended Chevron deference. Chief Justice Roberts wrote for the court. He said, under the Federal Administrative Procedures Act, it's for courts to interpret statutes, not agencies. So there's no reason the court can't decide for itself, no reason to defer to the agency. Justice Kagan wrote a blistering dissent. In part, she objected to the overruling of 40-year-old precedent, but she emphasized the expertise of the agencies and that courts should be giving deference to that. The other case came down the day before. It's Securities and Exchange Commission versus Jarchesi. George Jarchesi and his business were being investigated by the Securities and Exchange Commission for violating federal law and rules. A proceeding was brought before an administrative law judge in the Securities and Exchange Commission. The administrative law judge found that Jarchesi and his business had violated federal law and rules. The administrative law judge imposed a $300,000 penalty. Jarchesi and the business appealed to the United States Court of Appeals for the Fifth Circuit that ruled in favor of them. In this instance, the Supreme Court affirmed the Fifth Circuit, and again, it was a 6-3 decision. Chief Justice Roberts wrote for the majority, and he said, the Seventh Amendment creates a right to jury trial in civil cases in federal court. Before a civil penalty can be imposed by an agency, it should have to go to federal court where there's the opportunity for a jury trial. Here, it was Justice Sotomayor who wrote a vehement dissent. She said there's a long tradition of allowing federal agencies to adjudicate matters between the federal government individuals without even going to a jury. She said there are over 200 federal statutes that give to agencies the power to impose civil penalties. So in some instances, like for the Occupational Safety and Health Administration, they have no authority to go to court. It has to be imposed in the agency. What happens in these instances? I think there is a major ideological divide on the court when it comes to administrative law in the administrative state. I think the liberal justices want to adhere to what's been the premises for over half a century, that agencies are experts, courts should defer to that expertise. I think the conservative majority is much more skeptical of that and much more wants to allow courts to have the final say. The result of these decisions has been a significant shift from agencies to courts. And as a practical matter, the bottom line, it's going to make it much easier for businesses and those regulated to challenge agency regulations by going to court.
Miguel, any quick thoughts?
Yeah, I think these are two different kinds of problems. I think, Jarchesi deals really with the question of whether Congress can opt out of the Constitution by giving things to administrative agencies. The Seventh Amendment says trials are common law, you get a jury trial. Fraud is a common law tort. So the real question is, if you are accused of fraud, can you opt out of the Seventh Amendment by saying, no, we'd rather give you an agency? And the answer to that, says the court, is no. What he was charged with was fraud. And so what the court says is, like, you may want to charge him with fraud, but you've got to give him a jury. And so if you look at it in that light, it's not all that difficult. There may be cases, like an earlier case from the court called Atlas Roofing, where the court basically says that doesn't look like a common law tort, you can give it to an agency. And that's a horse of a different color. Chevron is a more interesting problem because there is a more traditional historic history of giving some deference to agencies. And I think, the problem that, the court eventually had with Chevron is that Chevron had two steps. One of them was step one, courts have to try very hard to figure out what the statute means. And step two, if they have wrung their brains out and they can't tell, then there is a role for deference. What it became in practice was many lower court judges said there is an agency, they have expertise, we'll skip to step two. And so in every case that was sort of hard, like FERC, anything that was technical, there was no effort to really sort of get to the statutory interpretation part. They went straight to the deference part. And in practice, there were a lot of litigants who said, we're getting cheated out of the role of the court here. And I think the court spent a lot of time trying to enforce the compliance with step one, and Chevron is a reaction to, failure on the part of the court to find a way to enforce discipline on the part of the lower courts with step one.
Thanks. Marianne, it's been 2 years since the court's decision in Dobbs overturning the constitutional right to an abortion, and the court had not one but 2 cases involving abortion on its docket this term. Can you tell us about those and what the court decided or didn't decide?
So one of the cases, the case called FDA versus the Alliance for Hippocratic Medicine, that one had to do with an abortion drug called mifepristone. And mifepristone has been approved since 2000 for providing safe medication abortion to women and girls. And it had not been uncontroversial, let's say, for some time, but certainly following the Dobbs decision, there became more and more scrutiny of things like medication abortion. And an organization that sort of assembled itself in the wake of Dobbs, this alliance, these are a group of doctors and dentists who are members of other anti-abortion associations. They got together and they said, we don't like the fact that this medication is being distributed. They didn't come out and say, well, we just don't like it and so it shouldn't exist anymore, because that wouldn't get you anywhere. What they said instead was, we think that there was an administrative violation here because of the way that the FDA handled mifepristone. There was not just the approval in 2000, but there was also a couple of different changes the FDA made for the accessibility of the medication, especially in light of COVID. They took away some of the restrictions in terms of having to see doctors in person, and so made it generally more accessible. This group said that's not okay. And what the court says here, and interestingly, this is a decision about standing, and this is coming from Justice Kavanaugh, so it's a conservative responding to another conservative decision. And here again saying, and it's back to the Fifth Circuit once again, to say you cannot just say that you're injured by something without really demonstrating the harm concretely, but also how it is that what you're asking for, and what they asked for and got in the lower courts was an injunction that meant that the medication goes off the market. They said you can't really just say because you have an attenuated feeling of harm about this, that means no one gets to have the thing you object to. So when the court says, we don't doubt for a moment that these are genuine, sincere objections to abortion and the fact that some people are getting them, but the kind of attenuated relationship you're setting out, that some doctor prescribes mifepristone, that causes complications. The woman goes to another doctor to have to deal with those complications. That doctor objects and is then forced to have to deal with the problem. The court says, that's all just kind of made up, right? You're just making things up. This is really kind of just speculative, too speculative, and it really just comes down to your moral objections to abortion medication, and that's not good enough. And so it was a really important, I think, restraint to say, just because we created, and the court certainly did create, the kind of impetus for these challenges to abortions and abortion medication, they are pulling back sometimes to say, well, we don't just mean you could always just take your emotional objection and succeed on this. What we have then is a case called Moyle, which is about a different issue. This has to do with emergency rooms and abortions, has to do with a federal statute called EMTALA, which says, for relevant part here, that if someone is in crisis, has an emergency condition when they show up to a hospital that receives federal funding, federal law says you have to stabilize that person. And that's really all it says. And what that means is, and the reason it became controversial was because sometimes what happens when pregnant people go to the emergency room is what they need to stabilize them is an abortion. Now, it may not mean that they need the abortion and they'll die, but it might mean they need an abortion or they're going to lose fertility, or they're going to have their kidneys fail, or some other really horrific, long-standing injury is going to result. So Idaho, after Dobbs, has a trigger law. Let's say it has an anti-abortion law that went into effect once Dobbs happened. And Idaho's law says basically you can't perform abortions outside of really tiny scenarios, including if she's on the brink of death. And if you do this, doctors, if you do provide an abortion, you're going to go to jail. It's a felony. And you're going to lose your license, suspended or lose it permanently if you do it more than once. And so there was a question of whether or not this is a conflict with the EMTALA statute that says, again, not specifically about abortion, just says you have to provide stabilizing care to patients. The Biden administration says, we know that these things conflict because of the way Idaho's law is written. It would conflict because it wouldn't allow those emergency stabilizing abortions to take place. So the administration says, you cannot let this law go into effect to the extent that it conflicts with EMTALA. And Idaho says, no, we certainly can. And so there's a big fight over this. And what ultimately happens is the Supreme Court picks this sort of off of its docket. It really does this unusual thing where it kind of intervenes before it normally would. And then when they finally make this decision, they say, we probably shouldn't have done that. And at this point, they have intervened in a way that has actually lifted the injunction of the Idaho law, which meant that the Idaho law that prevented, or at least created some confusion about whether or not doctors could provide that stabilizing treatment, went into effect. And women were very much suffering from this. So on the one hand, there's no conclusion in the sense that the court says, well, this was improvidently granted, so we're just basically not, it's like we never heard it. But as Justice Jackson says, well, it can't be like we never heard it because we intervened. We let that law go into effect. Women suffered because of this. And now we're going to say as a court, sorry, never mind. So she's quite angry about the choices that the court has made. This is another instance where the court is really looking at some of the most grotesque consequences of the decisions that it made in Dobbs and also in Bruin with the Rahimi case, and then basically tries to back away and say, you know, actually that does look really bad, and so we're going to try to disavow that.
Thank you. Greg, any very quick thoughts?
Sure. I mean, by far the most important thing about these cases is what the court didn't decide. And in both cases, the court dodged ruling on the substantive issue before it. Nevertheless, I think the decisions were important tactical wins for the proponents of abortion rights. In the Iowa case, the court left in place a stay against enforcement of the Iowa law that would have prevented abortions in circumstances that federal law, it was argued, would allow. And in the FDA case, the court set aside a stay on enforcement of the loosening of the rules by which you could obtain access to the medical abortion drug. I think, you know, in both cases as well, though, the court left the substantive issues so that they could percolate up again. They could get back to the court again. And there's no reason to think from the opinions here that if and when the issues do get back up to the court, the results could be different. I mean, the one thing that I think is most interesting about the cases, perhaps, is Justice Barrett's concurring opinion in the Moyle case out of Idaho, which was joined by the Chief Justice and Justice Kavanaugh. There's been sort of a side debate at the Supreme Court on the use of the so-called emergency docket, which is sometimes nefariously called the shadow docket, in which the Supreme Court takes cases before they're fully litigated and decided in the lower courts. And that's how the Iowa law got up there on the basis of various stays and injunctions that had been entered. And Justice Barrett, in that opinion, basically said, look, you know, lots changed since we agreed to hear this case. The parties' disagreement has narrowed. We really shouldn't go ahead and decide this case in this posture. We should kick it back to the lower courts to decide the case after full briefing and argument and consideration, which is more or less how the court operated more typically, you know, a decade or so ago. So to the extent that her opinion in that case suggests that the court may be more skeptical about taking on issues in the emergency docket, then, you know, that could be the more significant aftermath of that decision.
Thank you. Miguel, can you tell us briefly about the court's voting rights case this term?
Very briefly, this is Alexander versus South Carolina State Conference of the NAACP. This is a case about redistricting, basically. Following the 2020 census, South Carolina had to rejigger 2 of its districts because of population shifts. This South Carolina legislature basically announced that its goal was to boost the Republican vote in one of the districts, District 1, which is allowed. You can do partisan gerrymandering to your heart's content. You cannot, however, do racial gerrymandering. That's illegal. And in some context, there can be a correlation between partisan voting and racial voting, and it gets complicated. In this case, you know, the ensuing map was challenged, and it was held by a 3-judge court, which is how you adjudicate these things, to be a racially gerrymandered map, because in the particular ensuing district, the black voting age population went from 16.56% to 16.72%. There was an appeal to the Supreme Court, and the word appeal is important. This is mandatory jurisdiction. You know, the court doesn't get a choice whether to hear these cases. It has to take them. So unlike every other case where the court gets to choose whether it wants to hear the case, it has to take this case. It is an appeal, not cert. And so the court heard the case, and the fight at the Supreme Court was whether the district court was correct in its assessment of the evidence. So unlike every other case where the issue is, this is a weighty question of law, are we going to decide a great principle of law here? The fight here is which side presented the most persuasive experts. And the fight between the majority and the minority here, which was 6-3, as often happened this term, as Erwin said, was who was right and who presented the most convincing case. The district was in the end upheld in an opinion by the majority. It was a pure question of clearly erroneous review.
Fred, any quick thoughts?
Miguel is clearly right that this is ultimately a fairly narrow procedural question about whether burdens were carried, whether deference was adequately given to the district court's decision, as the dissenters say did not happen, whether the expert's opinion was not adequately weighed, as the majority would say. It's just irresistible to look under the hood of this one just for a second and to say part of this is about the problem of saying that partisan gerrymandering won't be looked at by the courts, but racial gerrymandering will be looked at by the courts, because the difference between the two is almost impossible in certain cases, and certainly this district in South Carolina is a good example where the difference is almost impossible to draw.
Thank you. We're going to go back to Fred in just a second to talk about what we in the press corps call the Trump docket, the Colorado ballot case and the presidential immunity case.
So why does the immunity case always come last? Well, actually, before talking about the immunity case, let me say a word about the Colorado ballot case. Actually, the two cases are worth looking at in double harness, not just because they're on the Trump docket, to be sure, but in each case, you have an opinion that represents the views of the 6 conservatives that we've talked about. In each case, you have a very noteworthy separate opinion by Justice Barrett, and in each case, you have a separate opinion in the case of the ballot case of the 3 liberals. In the ballot case, it's a concurring opinion, concurring in the result. Obviously, in the immunity case, it's a dissent, and a very bitter and barbed dissent of the kind of anger that Erwin talked about at the beginning of the program. Starting with the ballot case rather quickly, this was a case that goes back to a lawsuit that was brought in Colorado State Court by Colorado voters, claiming that former President Trump should not be able to appear on the ballot for the primary because under Section 3 of the 14th Amendment, having been engaged in insurrection on January 6th, he could not serve in a federal office. If he can't serve in a federal office, he shouldn't be on the ballot. The trial court found in Colorado that he had been involved in an insurrection, but said that Section 3 of the 14th Amendment does not apply to the president. The Supreme Court of Colorado said it does apply to the president. He therefore may not serve as president, having been engaged in insurrection, and if he may not serve as president, then he may not serve on a ballot. That case goes to the Supreme Court. I would just note that it was argued before the Supreme Court on February 8th. It was decided on March 4th. So apparently, when the court needs to move fast, it does know how to move fast. In the court's decision, and this is a unanimous reversal, so let's start with what the court all agrees with. All 9 justices agree that this is a matter of a state court, state law, state decision that purports to determine whether a particular person may run for president of the United States. I'm just getting a sign that says 1 minute left. I don't mean to call you out, but that's not going to happen. You're doing your job and I'm doing mine. So I tell you what, I'll finish the Colorado case in a minute. That I'll do. So all 9 justices agree that this is a federal matter, that the 14th Amendment, among other things, was a fundamental reworking of federal-state relations, a shift of power to the federal government, so it would be ironic at best if the 14th Amendment were used to give power to the states to decide who can run for president of the United States. The per curiam opinion goes on to say that it requires an act of Congress under the Section 5 of the 14th Amendment in order to implement the Section 3 insurrection clause of the 14th Amendment. The 3 dissenters say powerfully that that is not the case and that we need not reach that issue, but Justice Barrett, in an interesting and I think revealing sign of her emerging jurisprudence, says, look, we all agree that this is not a matter for a state court. I would have let it go at that. Let me just read you a couple of sentences from her opinion. She says, the court has settled a politically charged issue in the volatile season of a presidential election. Particularly in these circumstances, writings on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. This is the message Americans should take home. So I think that's a voice we'll hear more of from Justice Barrett. The dissenters agree that the issue shouldn't have been reached. They do it in a slightly more pointed manner, actually using language from the Chief Justice in the Dobbs opinion. Trump against the United States is the case involving presidential immunity. My guess is that this is one that is well known to many, so let me go through the holding, sort of setting up some of the context of it. The background, obviously, is the events of January 6th, charges brought against the former president of the United States. He claims the indictments are unconstitutional because of presidential immunity. That argument was rejected by the district court and by the Court of Appeals. Interestingly, the Court of Appeals took roughly as much time to make its decision in this case as the Supreme Court did in the Colorado ballot case, just about a month. The case then goes to the Supreme Court. It's put down for argument on the last possible day, 25th of April, and I think as is well known now, decided on the somewhat surprising July final day of the term, July 1st. Majority, in opinion by the Chief Justice, sets out 3 categories of instances of charges against the president: core constitutional functions, those that are conclusive and preclusive constitutional authority. That's language he takes from the steel seizure case in the 1950s. In those instances, there is absolute immunity. The outer perimeter of his official responsibility as president, that gets qualified immunity. Qualified immunity can be rebutted if it would not so interfere with executive authority. Here's what the Chief Justice says. He says, to rebut the presumption, the prosecution would have to show that the prosecution would pose no dangers of intrusion on the authority or functions of the executive branch. In her dissent, Justice Sotomayor says that is going to be almost impossible, and it fairly renders a nullity. Finally, there are the private actions in his private capacity, unofficial actions, and as to those, there's no immunity at all. Also of significance, the court says, and this is particularly significant for what's going to come next after this case comes down, it's not just that there's immunity for those official acts and that there's qualified immunity or presumed immunity in those cases that are within that broader, to use an old-fashioned term, penumbra of the executive authority, but that evidence of those, evidence cannot be used even for the cases of unofficial acts as to which liability may apply. If that sounds of relevance, that's exactly what Judge Merchan is going to have to be looking at when the case of the sentencing in the New York case, clearly one that did not take place within the presidential context, but on the other hand, evidence may have. So that's what he will be looking at in that case. Justice Barrett joins in that first part of the opinion, but not that second part. She does not think that the evidence ought to be barred from being considered. As she pointedly says, If there's to be a case, for example, of a president taking a bribe in order to appoint an ambassador, the jury has to see the quid and the quo, even if the quo would have been, by itself, something as to which there could not have been liability. The dissenters vigorously object to this extension of immunity, argue that the president, as a result of this case, is being put above the law. I'll conclude with a piece that is easy to miss. Typically, the choreography of the court is that a justice dissenting says, "I respectfully dissent." And so we all watch to see when the respectfully drops out and says, "I dissent." That means a lot more than a lay person might necessarily think just taking out the one word would. But that's not even how Justice Sotomayor ended her dissent. She said, "With fear for our democracy, I dissent."
Thank you. Greg, some quick thoughts?
Sure. So I think this is by far the most divisive case of the term, but I think it's also important to recognize that there actually was agreement on important aspects of the case. The government, during oral argument, acknowledged that there were certain core aspects of presidential power that Congress could not intrude on, and the lawyers representing President Trump recognized that there would be no immunity for unofficial acts. And that, left this great area in between, which the court ended up devising a category of essentially qualified immunity for, where there wouldn't be automatic guaranteed immunity, but there would be sort of a presumption in favor of immunity, and you would litigate that. I think another important thing to understand about this case is, although the focus is on presidents behaving badly, and one president in particular, this is really a separation of powers case. Separation of powers between the president in Article 2 and the Congress in Article 1, and a question of whether, to what extent, Congress could, by law, criminalize conduct that the president might engage in exercising his or her Article 2 responsibilities. And this is what Justice Barrett focused on in her concurring opinion. And the way she would have resolved the case is, instead of adopting broad terms of immunity, she just would have looked to whether or not Congress could have constitutionally passed law criminalizing particular areas of presidential conduct, and then allowed for appeals on that basis. And that's where her disagreement was. But I think it is important to recognize the separation of powers aspect of this decision. I think ultimately the decision for the court, like I think the country, was sort of a Rorschach test for whether you look at this case as one about the threat posed by presidents acting criminally, or the threat posed by presidents prosecuting their predecessors for alleged criminal acts. And on that, there were 6 justices in the majority who very strongly felt that the real threat posed by this situation was presidents prosecuting their predecessors, and in a situation in which presidents could no longer faithfully or fully or boldly exercise the authority granted by Article 2. The last point I would make is this is a case in which the court followed prior precedent, at least in some respects that were important to its decision. The basic framework and immunity concept that the court adopted was built on the Nixon versus Fitzgerald case, in which the court held that presidents were absolutely immune from civil litigation for their conduct while president. And so I think that the court did not sort of invent this regime out of whole cloth in that respect. Nevertheless, it obviously is a tremendously important decision for the court.
Thanks, Greg. I have been asked, and we're going to make up some time here, because I have been asked to talk a little bit about some of the cases that are already on the Supreme Court's docket for next term. And the reason that we can make up a little time is that so far the Supreme Court does not have the kind of blockbusters on its docket for next term that we have talked about so far today. They have 28 cases or 28 hours worth of arguments on their docket for the fall. They usually sort of try to fill their October, November, and December calendars before they go away for their summer recess. And there's 32 hours worth of arguments in that time. And they filled 28, which is actually pretty good, because there was a time when it didn't look like they were going to get anywhere near that. But they added 12 cases in their last 2 sets of orders at the end of June and the beginning of July. A couple of the big cases that are on their docket for next term. One is called Glossop versus Oklahoma, And it's something that's become a relative rarity at the court so far in the last few years, and that's a death penalty case. This is a case that is also unusual in the sense that the Oklahoma Attorney General has actually joined the inmate in this case in seeking to have his conviction and death sentence set aside. A case called United States versus Skermetti. This is the Biden administration's challenge to Tennessee's ban on puberty blockers and hormone therapy for transgender minors. A case called Free Speech Coalition versus Paxton. It's a challenge to a Texas law that requires porn sites to verify the ages of their users who use the sites online. And a case called Garland versus Vanderstock, which is a challenge to a rule regulating so-called ghost guns, which are firearms without serial numbers that you can assemble with parts that you can purchase online, including in a kit. The overwhelming majority of the cases that we talked about today, the Supreme Court actually agreed to take up those cases and review them after their summer recess. And they hear arguments from October through April, and so they only grant a small portion of those cases before their summer recess. So we could be discussing these cases this time next year, but we could be discussing many more, including some of the cases that we talked about in which the court didn't really weigh in on the merits of the cases. Some of those cases could bubble up back to the Supreme Court next term. We could also have some Second Amendment cases that come back to the Supreme Court. There are a variety of Second Amendment challenges that the Supreme Court sent back to the lower courts for another look in the wake of the Supreme Court's decision in Rahimi that could come back to the Supreme Court. So with that, we're going to turn it over to your questions. And so one of the first questions I have, aren't close to 75% of the court's decisions decided unanimously? Do we do a disservice to the court by not highlighting this fact and by focusing on the controversial 6-3, 5-4 opinions? Erwin, you have any thoughts?
The percentage of unanimous cases is much less than 75%. As I said at the beginning, out of 59 decisions, 23 were 6-3 and 5 were 5-4. In the average term, it's somewhere between 25 and 40% are unanimous. And we could say, well, look at all that unanimity. On the other hand, that treats all of the cases as if they're equally important. When you look at the cases that have the largest effect on people's lives, the largest effect on society, these are the ones that are usually divided 6-3 and 5-4. And what we focus on is the cases that matter the most.
Can I say something about that, though? I think you're overlooking one fact, which is you can't get into the Supreme Court unless the lower courts already are divided on an important question of federal law. So a threshold for getting into the court is that the question has to be at least important enough so that federal courts of appeals have found the question hard enough or important enough so that they disagreed over the outcome. Now, to be sure, maybe some of the questions are trivial in the sense that they don't matter to a lot of people, but there is at least a threshold sort of requirement that they be difficult enough to matter to some significant subset of Americans and be important enough to matter to the court in thinking that this will be hard enough and important enough to take as one of 60 cases in the year out of 12,000.
I think just to jump in on that question, which is a great one too, I mean, I think it is an important question because I think if you think of the court as a monolithic 6-3 court, that you have the wrong impression of how the court actually operates. And there's actually a surprising degree of action among the justices and volatility among the justices. In this term in particular, we saw a number of surprising alignments. And I think Erwin's right. And many of the most important cases, and certainly cases in particular areas like agency action, they tend to break up into traditional blocks. But the court as a whole is much more interesting and volatile than might be presented just by looking at a small subset of cases.
Here's a question that I think follows up on that, which are the strong disagreements among the justices irreparable? If so, what are the consequences of that going forward? And I guess I would add, if not, how would they be repaired?
I think irreparable is a funny word to use on this because it almost, it over-personalizes a lot of this. It's not that they don't like each other, it's that there are very deep disagreements methodologically, maybe even ideologically, and yet, as Greg says, there is movement in certain areas amongst them, and I think one of the things that's been commented on a great deal is the fact that Justice Barrett seems to be emerging as a unique voice, a powerful voice. I'm not going to say that a liberal voice or a conservative voice, I think that kind of misconceives it, but an interesting voice in a different way. So I don't think the differences are irreparable. I think they continue to listen to each other. And has famously been observed and gets quoted every time there's a new justice on the court. Every time there's new justice on the court, it changes the entire dynamic among the 9 of them. So I think that's also a time in which there's a re-examination of a lot of these things.
I do agree that Justice Barrett has proven herself to be very interesting this term. One of the things that I thought was most interesting, if we sort of back up and think about how the Roberts Court has tried to sell this idea of itself being history and tradition. We're going back to constitutional principles. We're being originalists. We're settling the law. We're calling balls and strikes. And they tried this, they tried to do this in Rahimi, but it was hard for them, right? Because the author of Bruin that they're supposed to be applying, Justice Thomas, says you did it wrong. So already you have this disagreement about, what do you mean history and tradition? How is it that it's more objective? You would expect that the liberal justices would criticize this, and they have vehemently, to say, this is picking your friends, this is this is judicial activism. But what's really interesting is that Justice Barrett, I think, is also contributing to that critique. So when she says in Vidal v. Elster, she has this interesting aside about how she doesn't understand why history is the right way to decide First Amendment questions about trademark. She says that doesn't really make sense as an interpretive approach. And she comes very close to saying, and maybe she even really does say, that this is really kind of picking your friends, right? It's a very selective use of history. And she's also really clear, very clear on this point where she says, to the extent that history and tradition is being presented as the objective, non-activist, non-policy choice, which it very much is, being presented that way, she says, saying that history or tradition prevails is a policy choice. Now, again, that's not a surprising thing to hear from a liberal justice. It's a little surprising to hear it from Barrett. And I think it really does drive the point home that to the extent that the court is having to really try to cling on to its legitimacy by saying, hey, we're not activists. You look at a term like this, it's very hard to say this court is not activist. And I think it's very important that Justice Barrett is willing to say, you're making policy choices. Don't pretend that what you're doing is neutral or objective or somehow more settled. And also when you've got the liberal justices coming in, like Justice Jackson, to say, you're causing chaos everywhere, right? You decide a case like Bruin, and then you scold the Fifth Circuit for not getting things right, when in fact Bruin is setting out a certain type of test that all the courts have been saying, we don't know how to apply this. There's chaos everywhere is what many of the liberals are saying, but I think also Justice Barrett is gesturing towards.
Does anybody else have any thoughts on this Justice Barrett, Erwin?
What we've got to keep in mind is that Justice Barrett overwhelmingly votes with the conservatives. She was in the majority in overruling Roe versus Wade. She was in the majority with regard to ending affirmative action. She was in the majority in Trump versus the United States. She's in the majority in the administrative law cases. In response to the specific question, in terms of reparable difference, take 2 examples. Samuel Alito and Sonia Sotomayor look at the world as differently as 2 people can possibly look at it. There is no bridge between their ways of looking at constitutional law. And I think when you look overall at the Supreme Court has its lowest approval ratings in history. Some of that is because of the ethical issues surrounding it. Some of it is at a time when our country is more politically polarized than it's been since Reconstruction. What will it mean to have a Supreme Court that's so clearly come down on one side of that divide and so far to the right on that side of the divide? And I think that's going to be the crucial question for the court and its legitimacy for the future.
No, but I think if your question is, I am concerned about the questions, about a court's legitimacy, I think, the Barrett opinions are an important contribution to the conversation, right? Because if you've been reading each of them for the last several terms, if you read, for example, her concurrence in the major questions case, where she went, it's important to figure out where this comes from and how far it reaches and what it means and what it doesn't mean. It is an important sort of point to understand how far she's willing to go with it and how far she isn't. If you read her concurrence in the Trump immunity case, it's very important to say, to read her, to say there are certain core jobs of the president for which he could not possibly be criminally prosecuted by his successor. And there are certain things for which it is just silly to say he could not. Like she has a footnote saying the fake electors thing, that is a job of the states. I don't see how you can give him immunity for that, even though you are purporting to do that. It's important to sort of read the opinions to see how she explains the results on the job, because explaining how you get there, it's a lot of explaining how you think the result is legitimate.
So I guess to follow up on that, sort of given what you've said about Justice Barrett's thinking, assuming that this court remains the same for the next few years, where do you see this court going? I mean, does it continue to move to the right? I mean, does it reach a point at which Justice Barrett will say no more?
I mean, the assumption that the court is conservative generally at a gross level is correct. I think it tends to overlook that the conservative justices don't agree on a methodology. And that justices like Justice Alito, Justice Thomas, and Justice Gorsuch have a different view about how to interpret the Constitution and statutes than Justices Barrett, Kavanaugh, and Roberts. And depending on the facts and the context of the case, you may find those three being in agreement with what you think of as the liberal bloc of the court. And where the court is going may well depend on the nature of the cases in front of the court. Will you think that in Gross the outcome is conservative? Quite possibly. But that will depend on the problems that confront the future of the country, not necessarily on the nature of the court.
There's an interesting way in which they talk to each other through the footnotes. The fact that the example of the bribe to appoint someone as an ambassador didn't come out of nowhere. That came out of oral argument. And at oral argument, the Chief Justice appeared to take the position that Justice Barrett takes in her concurring opinion. And she has a footnote that speaks to the Chief's footnote that essentially says, I'm paraphrasing, not paraphrasing, actually, I'm just describing, as if, I thought we talked about this. I thought we were in the same place on this. And the Chief's footnote, which I've read a number of times, I find impenetrable. And part of it, I think, is that she is challenging him publicly to say, I thought we had this together. Now, what's the significance of that? If he had, in fact, agreed with her on that, then the 5 is lost, actually, on one important point of the case. Now, it's not what happened. Right? You have 5 justices for a very broad view of immunity. But it was close on that. Dobbs, 2 years ago, if Justice Barrett had taken the position that the Chief had in his concurring opinion, you lose the majority there. So it's not what happened, but there is an interesting discussion going on through the footnotes between them in particular, I think, and this kind of Brandesian idea that if we're not obliged to decide it, we're obliged not to decide it. If that takes hold, that could pull the court back to a certain extent. Having said that, I think you still have a very conservative court with this configuration. And when major issues come up, you're likely to get, on the major kind of issues we'll be talking about year after year, something close to the 6-3 towards a conservative result.
So I think what's important to understand about this court is it's not a court in which one justice can swing the court. So we had like 15, 20 years of a court in which it was typically a 5-4 court that could swing either way. So Justice Barrett is very interesting, I agree, but getting Justice Barrett's vote doesn't mean you're going to get 5 votes. You might end up with, 4 votes. But I think what is notable about this term is we saw more of the 3 justices who tend to occupy the middle now, the Chief Justice, Justice Kavanaugh, and Justice Barrett, being able to moderate some of the decisions and coming together in some of the decisions. Whereas in other cases, for example, going back to Dobbs, the Chief Justice wrote alone, urging a narrower course than completely overruling Roe. Maybe bringing that forward, maybe there would have been more votes for that, whether or not it was 5 votes for that or not. But I think in understanding the court, the way what this term suggests is really a sort of a 3-3-3 court with the 3 liberal justices, the 3 more conservative justices, Thomas, Alito, and Gorsuch, and then the 3 justices in the middle who are deciding most of the cases and agreeing on the more contentious cases, the Chief Justice, Kavanaugh, and Barrett.
With the friendly amendment, I hope that Greg would agree that when we use the term 3-3-3, that the mind goes to 3 moderates, 3 conservatives, 3 liberals, and that's not, in fact, the configuration of this court. It's 3 liberals, one of whom is actually relatively moderate by most long-term measures of the court, 3 conservatives and 3 extreme conservatives.
I wouldn't agree with those characterizations,
well,
but the basic framework, I think, is...
Fair enough. Then an unfriendly amendment that may not have been accepted.
I will make an unfriendly one to yours. I will say that what we think about where each of the justices is also changes with the mood of the country. In the days of the New Deal, Felix Frankfurter was thought as a great liberal justice and an appointment to the court that would bring a great liberal to the court. By the time he was done, he was thought as a right-winger on the court. And he hadn't changed. The country had, and many of his colleagues had.
In answer to your question, I think the court's docket in the years ahead is going to continue to have the issues that most divide society: abortion, guns, religion, transgender rights. But I want to go to something you said in passing. Assuming the court's composition stays the same, I'll go out on a limb and make a prediction. If Donald Trump wins in the Republican Senate, Clarence Thomas and Samuel Alito retire, so those seats can be filled by 40 and 50-year-olds. Conservatives will hold those seats for decades to come. I think if Joe Biden wins and the Democrats have the Senate, Sonia Sotomayor will retire. So the presidential election in November is going to matter enormously. The most long-lasting effect of any presidency is who the person puts on the Supreme Court.
And I think you have the last word. And thank you to the ADL and to the National Constitution Center for hosting us. Please join me in thanking our marvelous, marvelous panel.